Here this time we can organize something that will be live, and we will have participants both from Croatia and from Brazil. I was supposed to do the closed event, but I got the opportunity to open the event, and thank you for that, because I will be leaving a bit before the closure of the event, because I have other obligations. The fact that I'm the Vice Dean for Science and International Cooperation and Postgraduate Studies. So it is actually the business obligation regarding the faculty. Here today, on my regard, are my students from the 5th year. These are the students that are enrolled in the European law module. I would kindly ask all the participants to turn on the cameras, if not all, most of them that are able to turn on the cameras, and I know that they are able to turn on the cameras. So we will have the live picture of our students and people who are participating. It's always nice to talk to someone and not only to yourselves. I will just give one last point to my students from the 5th year, from the class of EU Internal Market, just to mark your attendance at Merlin. From Croatia, we also have our Erasmus students. So we have, in this semester, 10 students coming from actually Portugal and Spain, and they are some of them have enrolled my class of EU Public Law, so I have invited them to attend the class. It is in English, and I'm sure they would understand in Portuguese also, but they will be participating and listening in English. And at the end, I want to say and greet all the speakers that will be speaking after me. Today's topic is actually focused more on the EU law and human rights protection. And I'm hoping to give some basic introduction about the human rights in Europe. I have started from basics. Maybe our students know more, but I'm not sure how Brazilian students are actually in the knowledge of the human rights protection in Europe. So I hope these basics will help and maybe lead even to some discussion. I will not be too optimistic due to the fact that most of the students are not happy to be talkative via Zoom, but maybe they can write something in chat and whatsoever. So if you give me the opportunity, I will share my presentation and then start with actually my part of the. Is that okay, Paula? Okay.
Please try to share.
Okay. I have muted myself instead of sharing the presentation. I hope everybody is able to see the presentation. I will start the slideshow now, so hopefully it's visible to everyone. I will try to keep myself in the time that I'm limited for, and give the room, as I said, for discussion further. So my topic is very general. It's human rights protection in Europe. I have deliberately said Europe, not European Union, because the human rights are actually protected on many levels in Europe as a continent. So for basic introduction is something from the basics of law that I'm sure that all the students cover also in Brazil and in Portugal and Spain, Croatia, whatsoever. So what are actually the human rights itself? Those are the basic rights and freedoms to which the humans are entitled by being born. They are universal and fundamental. Why do we say that they are universal? We say that they are universal because everybody is born with the possession of these rights. Only by the basic fact that we are born, we have human rights. And they are fundamental because they are not awarded by the human power and cannot be surrendered at any time by any legislation. So this is the basic definition, and what we experience and what we see every day is actually the violation of these human rights that should be something that is given to us with the basic fact that we are born. So here I have some questions for the students. I hope somebody will answer, so this could be interactive. Can you tell me, please, in English? I know that maybe you are not so talkative in English, but it's a basic question. So which human rights can you think of? Can anybody think of any human right, or the first human right that it comes in fact when somebody says human right?
Right to life.
Right to life, okay.
To work and education.
To work and education.
Liberty.
Liberty. Anyone else? Does anyone know how are the human rights protected? Okay. Is somebody speaking? How do we protect human rights? Or do we have to protect the human rights if they are given to us by the basic fact that we are born with the possession of the human right?
Laws and constitution can protect human rights.
Laws and constitution can protect the human rights. Great. Can something else protect the human rights between laws and except laws and constitutions? So this is the actual answer to the question. It is, as was said, they are protected by constitutions, basically, at the national level. And we can protect the human rights also at the international level by the international declaration and treaties. And I'm sure that somebody can think of some international document which regulates human rights. Nothing?
Pacto de São José da Costa Rica.
What?
Pacto de São José da Costa Rica.
Okay, Costa Rica. I understood Costa Rica.
Yes. No, I am Brazilian student.
You are a Brazilian student. Okay. And you refer to which documents? That international document that protects human rights?
San Jose Pact.
São José da Costa Rica, Pacto de São
Okay. Do you know any other? Do you know any European treaty or document that protects human rights? Maybe somebody from Croatia or Spain or Portugal can know that.
European Convention on Human Rights.
Okay, perfect. Except European Convention on Human Rights, we have also another document that protects human rights that we will be talking about today. So, as we understood, there are a number of international treaties that protect human rights on regional level, basic international level in the UN, and then we have what I want to talk to you about today is the European documents, European treaties that protect human rights. So what I want to distinguish first is what is Europe and what I will be talking about. And here is a basic division between two international organizations in Europe that are leading in the protection of human rights in the international level. I will not be speaking about the protection of human rights at national level, but only on the international European level. And here I have put the information about the Council of Europe and the European Union. For students in Europe and general public in Europe, there is still much confusion between what is Council of Europe and what is European Union. And I can expect that for Brazilian students, this is even more confusing. So this is the basic division. So these are both the international organizations that have a different legal background and that are based on the different treaties, but they have overlapping members. First international organization that was created was Council of Europe. It is the organization from 1949, first established by 15 members, and now it has 47 members from Europe. Only European countries can be members of the Council of Europe. You see here the number of people included. So the Council of Europe with the 47 European states has around 835 millions, and the European Union has the half. European Union is the international organization that was created in 1957 by the Rome Treaty, starting as European Economic Community, now being the European Union. As you maybe know, it had 28 members, so the UK left, and now it has 27 members. European Union is a specific international organization with specific legal order. It is what we say more than international organization, like the sui generis body in the international law, because it provides, its treaties provide obligation not only for the state, but also for the citizens of the European Union. Each citizen of the European Union is free to call to any article from the Treaty of the European Union, which we don't see in international treaties, and which is not the fact, for example, in the Council of Europe. Both these international organizations have the same flags and anthem. It is Ode to Joy, and you can see the flag. In these organizations, we have the protection of human rights provided in treaties, in actually one convention and one charter. And I will be talking today about European Convention on Human Rights, which is the convention of the Council of Europe, and the Charter of the Fundamental Rights, which is the convention, the charter that is part of the EU law legislation. I will talk about the overlap of these documents and the difference in application of these documents in Europe. You are free at any time to ask me any question and to stop me if I may be being too fast or you don't understand something. In line with both of these treaties, conventions, we can call them, what we have and what is something of the great importance is judicial protection of human rights. We know that we have many treaties that protect human rights internationally and nationally, but these are the only treaties or conventions regarding human rights that can be protected in front of the court and that can be invoked in the judicial procedures. The court that protects citizens against violation of human rights that are guaranteed in the Charter is the Court of Justice of the European Union. It is the institution of the European Union. And the court that protects the violation of human rights that are prescribed by the European Convention on Human Rights is the European Court of Human Rights. So these are two different courts. We call them both European courts. They interact. It is the complicated relationship with these courts, but they are, and what should you bring from this lecture? Completely different courts from completely different institutions and completely different international organizations. So first, something about European Convention of Human Rights. So the convention was signed as an international treaty. It dates from 1950. It was signed in Rome at that point by the 15 members of the Council of Europe. It entered into force in 1953 when it was ratified by all the member states. So it's like a general international treaty. Today, Council of Europe has 47 member states, and they have all signed the Convention of the Protection of Human Rights as a basic document of the Council of Europe. And this convention applies for this state after the signature, and the protection of the human rights by the convention applies after the signature. For example, the Croatia joined the Council of Europe in 1996, and this convention applies in Europe, in Croatia from 1996. So you can invoke the violation of your human right by the violation of the Convention of the Protection of Human Rights from 1996. So convention is a complex treaty that I, in these 30 minutes, don't have so much time to explain each right. So this is how it's actually organized, the convention. It has rights and freedoms. It also has the prohibition, so prohibition of torture, prohibition of how I forgot the English word. So the forced labor. It has so rights and the prohibitions. It has all the articles about the functioning of the Court of Human Rights, and it has protocols. Protocols are a really important part of the European Convention of Human Rights, which was signed in 1950, and it changes by protocols. Some of the protocols have to be ratified by all the members, and some of the protocols can be signed by some of the members. It is two kinds of protocols. If there is a change regarding the court itself, it should be ratified by all 47 member states, and then it applies. And if there is a new right being introduced within the European Convention of the Human Rights, then parties can choose if they want to sign or not. For example, we have a protocol on death penalty that was not firstly existing in 1950. And there are still actually three European countries that have not signed this protocol and that are allowed to have a death penalty. Here are the rights, just the bunch of rights protected by the European Convention of the Human Rights. As I said, I don't have time to explain each of the rights. The rights are protected within the Court of the Strasbourg, but they are firstly protected at the national level. And I just want to add one more specificity of this court, and it is that all the individuals have the right to access the court. So these are the proceedings that start by individual, but firstly, they should exceed all the protection of human rights at national level. And after the decision of the highest national court, which doesn't recognize the violation of human rights, each person can start the procedure in front of the European Court of Human Rights and ask for the protection against its state. So it's always the case like Dunja Dujic against Croatia. So it's always individual against the state regarding the violation of the right. I hope that you can follow and that you understand these basics. So the second document that protects human rights in Europe is Charter on the protection of human rights. It is the document, as I said, of the European Union. The European Union itself has three sources of protection of the fundamental rights that are prescribed in the treaties of the European Union. First, it says the Union recognizes the rights, freedom, and principles set out in the Charter of the Fundamental Rights of the European Union, which shall have the same value as the treaties. So it is the highest level, the primary source of the European law. Also, the Union, as all the members of the Union are the members of the Council of Europe, guarantees the rights that are protected by the European Convention of the Human Rights, and they constitute the general principles of Union law. And third, what is most important is that the Union itself, as a legal person, as the subject of international law, is in the process of becoming a member of the Council of Europe, and should be acceded to European Convention of Human Rights. This process is really complex and it has some problems. And it's actually the clash between courts, where the European Court of in Luxembourg, the Court of Justice, doesn't want to give some jurisdiction to the European Court of Human Rights. But the process has started, and at the point when the European Union accedes the European Convention on the Protection of Human Rights, at that moment in time, the citizens of the European Union would be able to start a procedure against the European Union in front of the European Court of Human Rights. But it has still not happened, and it is, as I said, a complex process. The Charter itself brings together the fundamental rights of everybody living in the European Union, and it takes in its range everything that is prescribed in the European Convention of Human Rights, the constitutional traditions of member states, the Council of Europe Social Charter, and in all the international conventions which EU and member states are participating in. It was adopted in 2003, and it has become legally binding to all EU member states from the 1st December 2009, when it became the part of the Treaty of Lisbon. So, as I said, it has the same level in the range of legal protection in Europe. This is actually, the charts are from the European Union Agency for Fundamental Rights. I will refer you to the website of this agency. It is the special agency of the European Union for the protection of fundamental rights. And there you will be able to find more literature on this topic if you're interested in. How are the human rights protected in the European Union? It's actually visually prescribed here, what I have said already. First of all, constitutional of the member state, they are used to protect the human rights. Then we have the general principles of law, which incorporate the rights from the European Convention on Human Rights. And then we have Charter. Afterwards, we have the Council of Europe standards, and then at the top, the United Nations standards. In practice, it works like this. So we have a violation of the human right by a member state. At that point, we have to see if we apply the Charter or do we apply the Convention on the European Convention on the Human Rights. We will apply the European Convention on Human Rights if it's the violation by the country itself. And then this, as I said, a violation should be invoked in front of the national court. And if the national court doesn't recognize the violation of the human right, then we have the procedure in the European Court of Human Rights. If there is a violation of fundamental right involves the implementation of the EU legislation, then we apply the Charter. Again, the protection starts at the national court, and then is referred to the Court of Justice or the European Union or the European Commission. It depends of the if it is a legislation or the Charter or whatsoever. So these are the two ways how these documents are applied. Here you have just like numbers of references that happened regarding the Charter. So you can see this is 2016, but more or less the numbers are the same. Mostly the Charter is applied as the citizen want to invoke the right to an effective remedy and for a fair trial. This is the basic overview of the rights that are prescribed in the Charter. There is 54 articles in the Charter. They are actually divided in 7 sectors. And what I want to show you, and coming to the end, is that how they overlap with the European Convention on the Human Rights. So maybe you can focus on the red circled rights, where you can see that, for example, this protection of these rights is prescribed in the Charter, but it is not prescribed in the European Convention on the Human Rights. We have to acknowledge that European Convention on the Protection of Human Rights is adopted in 1950, and Charter is adopted 50 years later. So we can say that is a more modern document in line with the times that we live in. What I personally do and what I write about is a lot about asylum. And you can see in Article 18, for example, that this charter has the right to asylum recognized as a human right. It is actually the only document of international document recognizing the right to asylum as a human right that exists today. So how do this overlapping works? Although they work in the separate legal frameworks, the Charter is actually drafted by the EU and interpreted by the Court of Justice of the European Union, as I said, European Convention on the Human Rights is drafted by the Council of Europe and interpreted by the European Court of Human Rights. But European Court of Justice of the European Union also invokes the rights from the European Convention on the Human Rights, and the Council of Europe does not do that. What we have experiencing today is that both courts in its judgments call on the judgments of the other courts, but mostly is the Court of Justice of the European Union that uses the practice of the Strasbourg Court, unless we see referral to the judgments of the Court of Justice of the European Union in the Court of European Court of Human Rights. And at the end, I have mentioned a lot of case law, which I cannot fit in within the 30 minutes. This is the website when I will now stop sharing and send you the website and I will send you the website in chat, so you can browse to the this database of the human rights law. It is really detailed database, so any human rights that you are interested in can be found here. Share screen. When you open it, you will see this. You can select the articles from the Charter and the articles from European Convention of the Human Rights, bodies, countries, and browse through the case law of actually both courts. And yes, I will stop here. I think I'm within my time frame. I hope that I really don't know the basic knowledge of the Brazilian students about the human rights protection in Europe. So maybe I have repeated something that they know, or I have given them something that they generally don't have any idea about. I don't know. I hope that it was helpful. And we have how is Europe dealing with the violation, I suppose, of the human rights since the Taliban took over in Afghanistan, I suppose is the question. Well, Europe is dealing with that like is dealing with everything. We had a meeting that we should have a meeting about a meeting, and in generally issued a number of statements. At this point, we are still, some countries are trying to get people come back from Afghanistan. We have not done anything what is operational because we don't have European army. But building on this, what happened in Afghanistan, we have strong suggestions from France that we should start the possibility that we have in the treaties to organize a really existing European army and the protection of, not the protection, the creation of self-defense as we have in NATO. But we will have to see the election in Germany and now the new German chancellor and how will this work within the political ideas. Before that, only thing that European Union can do at this point is send like a humanitarian aid in Afghanistan or send good wishes that are prescribed in the nice statements, and hope that we will have not any more terrorist attacks in Europe. So this is, I think, maybe not the answer that you expected, but this is actually the reality of the European Union today. And the fact that there is the violation of the human rights in Afghanistan is something within the international law, where European Union can give sanctions and economic limitations whatsoever, but we cannot put on trial any person living in Afghanistan or violating human rights there. We can do that only if it happens in Europe, in the field of European Union, Council of Europe. So, yeah. I hope you are satisfied with the answer. Not satisfied, but that you have gotten the answer that you wanted.
Thank you so much, Professor Dunja. And somebody else want to talk or any other question besides Barbara? No?
I have a question too.
Okay. I want to say hi to Professor Walter that entered right now. He is our coordinator about this international event. So let's go, Felipe.
Good morning, everyone. First of all, I would like to compliment Professor Dunja for her lecture, and also to compliment my classmates and everyone from Croatia and my professor and tutor, Hugo Segundo. Well, it's actually a thought followed by a question. We see a lot of human rights treaties worldwide, which is a good thing, of course. However, many governments refuse to apply these treaties in practice. That lead us to think that human rights law is somehow utopian and that human rights treaties have failed. Are there ways to enforce the effectiveness of human rights law?
Well, as I said at the beginning, what we have in the Strasbourg court is actually also in the Luxembourg court, but I will focus on the Strasbourg, the European Court of Human Rights, is that we have the way of enforcing the protection of the human rights is not much. It is basically the country gets the financial consequences for the violation of the human rights. But in its essence, if a country doesn't want to fix something, it will keep paying these financial consequences to the Council of Europe without fixing actually the problem that exists. But still, what we experience in Croatia is that when we get a few decisions from the European Court of Human Rights, we change the laws and we try to make things better within the protection of the human rights in Croatia. Sometimes it works, sometimes it doesn't work. For us, the biggest problems are the conditions in the jail system, the long period of the trials before the court, and general discrimination of national minorities. So these things are changing slowly, but they are still changing. But I cannot say, okay, we have the same prisons as in Netherlands, because we don't have them. But it keeps countries aware of the violations, and it keeps countries on the way of fixing things. It's slow things. So at this point, I don't see as being it as functional as it can be, but I would not have any other solutions, because the countries in general are not so willing to give its sovereignty to any international organization. And what we are experiencing in the European Union, where countries have given the large part of sovereignty to the European Union, is that we still have the problems in the application of the European law. It same goes for the charter. So you can always get, when you start the protection regarding the charter, you can always have a decision of the Court of Justice, and then you can have financial consequences. And within the European Union, these consequences are much higher than in the Council of Europe. So if you get a decision from the Court of Justice in the infringement procedure for the violation of the human rights, then it is we talk about the millions of euros for a country to pay. So I think this is the only way actually to make countries do something to be more operational. I hope I have answered the question.
Thank you, Professor.
Thank you so much, Professor Dunja. It was a really pleasure to receive you, to listen to you this morning here in Brazil and this afternoon in Croatia. So now I want to invite our professor, Professor Hugo de Brito Machado II, please. He will talk about autonomy and effective principles in Europe case law. He will talk about European Court of Justice and due process of law. So Professor Hugo, please.
Thank you very much. Can you hear me?
Yes.
Good morning to everyone in Brazil. Good afternoon to everyone in Croatia. It's a pleasure to be here. I would like to compliment Professor Dunja, Professor Denise, Professor Paula, and I'm very grateful to be invited to this Congress. I hope I heard Professor Dunja talking about face-to-face events, online congresses, but also online conferences, but also face-to-face conferences. I hope that we can organize face-to-face conferences soon, indeed, and especially with professors from Croatia. That's a lovely country. I've been in Croatia in 2018. It's a very beautiful country. And I hope also that we can host you from Croatia. We can host you here in Brazil as soon as possible. It's a pleasure for me, as I said, to participate in this conference organized by Unicristus and by Pravos University in Croatia. And I would like to address an issue related to human rights and access to justice. My lecture will be like a second part maybe of Professor Dunja's lecture, because I'm going to talk about a specific point related to ECJ case law, European Court of Justice case law, and the lessons that we can learn from this to apply in Brazilian reality, to apply in Brazilian law. Indeed, I would like to talk about a contrast between, or a clash between, two very important principles in European law: autonomy principle and effectiveness principle, and also about the consequences of this clash, the clash between these two principles in European Court of Justice, ECJ case law, regarding especially to procedural law issues, to due process of law and procedural law issues. So in short, let's talk about access to justice in Europe and the access to justice, especially to the effectiveness of rights and freedoms guaranteed by union law. All these human rights that Professor Dunja talked about, when they are violated, what can be done, and the enforcement of these rights is related to the domestic law, and the autonomy principle prescribes that each state member should be autonomous to decide how to enforce these rights. So let's talk a little bit about this. And in the end, let's make a contrast between these issues and the way the same issues are addressed in Brazil. In European law, as we said, and as we just heard, there are a lot of rights, freedoms, and liberties that are guaranteed by community norms, community provisions, norms from union law, treaties, especially, as Professor Dunja just told us about. Rules on how European citizens should be treated, on their freedoms, on how they can organize their lives, and how they may be taxed. And for those, I'm in Unicristos and in Federal University of Ceará, I'm professor of tax law also. And for those who think that taxes are not related to human rights, it's worth remembering that fundamental rights and the documents, the provisions that guarantee them, they all have emerged or appeared or come to light as consequences of revolutions caused by problems related to taxation. We can just remember French Revolution, the Great Charter of the King John, American independence. All these revolutions were related or caused by issues related to tax problems, to taxation in any way. Well, in Europe, as I said, many freedoms and rights, the so-called substantive law, they are enacted by union law norms, treaties, which state members must respect and implement, as Professor Dunja just teach us. But the enforcement of these union law provisions depends on each state member, on each member state. Hence, each one has rules, provisions on administrative law, on procedural law, linked to how such freedoms will be realized, respected, implemented, or protected. The way, for example, the way European employees should be treated, on how European taxpayers should be treated or should be taxed, for example, all this is prescribed by union law rules. But if these rules are not respected, the procedure to claim the respect, to deal with the violation of union law, is regulated by state members' domestic law. As I said, administrative law or procedural law. Domestic law will determine or prescribe to which authority one is supposed to claim. That's why I alluded to autonomy and effectiveness principles and a possible clash between them. Why a clash? Because according to autonomy principle, each member state has autonomy to decide and regulate how to enforce European law, union law. That's why Germany, Italy, France, Spain, etc., they all have different rules of administrative law and procedural law. We talk about Italian procedural law, German procedural law. Each state member has a different civil procedural law or criminal procedural law. In each of these countries, there are different ways to proceed in case of violation of substantive European union law. Although European employees in France or Spain have equal rights, for example, the way to claim for judicial protection in case of violation of these rights is different. The authority before which to claim is different. The deadlines to be met, the burden of proof, everything is different or may be different in each state member. Because each country has, as I said, rules regarding procedural law. They have autonomy for that. That's what autonomy principle means. But in turn, according to effectiveness principle, in one way or another, such autonomously established rules of procedure on how to enforce union law, they must really make European law effective. In short, state members are free to choose how to enforce union law, but they must do it somehow. That's what effectiveness principle means. And from this contrast, a very interesting case law emerges in European Court of Justice, ECJ, a court that decides only issues related to European law, as Professor Dunja just told us. ECJ doesn't decide issues related to domestic law, to state members' law, just regarding to violations of union law. So that's why, in principle, in theory, we should not have case law in ECJ regarding to procedural law, to domestic procedural law. So issues related to the comprehension of Italian law, French law, German law, and to the effectiveness of Italian law, eventually a violation of French law, they are not taken to ECJ, but only questions about how to understand and apply union law provisions, European law. That's why usually, as I said, ECJ case law does not deal with procedural issues, since the procedural law is related to the enforcement of substantive law, and therefore procedural law is ruled by local or domestic law only. However, there are situations in which procedural law norms or provisions enacted by a state member in respect to the autonomy principle makes impossible or very difficult to enforce union law. And that's interesting because in these situations, we see that the distinction or the separation between procedural law and substantive law is not very clear. And the relation between these two groups of norms are very intense. One depends on the other. And this situation shows this. There are situations in which if excessive weight is given to autonomy principle in order to allow each state member to establish procedural rules with any content, even when these procedural rules makes impossible to enforce union law, effectiveness principle is violated. And in such cases, ECJ admits to deal with the issue and declares invalid state member domestic rules on procedural law due to incompatibility with effectiveness principle. The repayment or the reimbursement of indirect taxes is a good example of this that I'm talking about. In Europe, in the 70s, the 70 years, the 70s in last century, 20th century, some countries started to enact provisions, procedural rules, provisions, prescribing that indirect taxes, even when unduly paid, even if the taxpayer pays an unduly tax, it's not supposed to be paid, but it's paid anyway. This tax should be reimbursed or refunded or repaid to the taxpayer only if the taxpayer proves or demonstrates that they did not shift the tax burden to consumers. This is known as passing on defense. When, for example, a store sells something and has to pay the VAT, the value-added tax, but the VAT is unduly paid. It was not supposed to be paid. So the government says, I'm not going to refund you because you already put the VAT in the price of goods and services that you sell to consumers, so it's not going to be refunded. This is known as passing on defense, as I said. So when a state member charged a tax against union law, when this tax is charged in a violation of, causing a violation of union law, for example, violating the obligation that state members have to treat equally each citizen in Europe. For example, a company from Italy should pay the same taxes that a company from France is going to pay, and or a product, a good drink, liquor from France has to pay the same tax that a liquor from Italy has to pay also. But imagine that in one case, Italy wines are taxed with a rate higher than French taxes, French wines, for example. In this case, the tax is charged in violation of union law. In this case, when a state member charged a tax against union law and community law in that time, in the 70s, and the taxpayer claimed for the restitution, state member courts, domestic courts, they decided that the restitution was not possible because the taxpayer did not prove that he did not have shifted the burden of the tax to consumers. And ECJ initially accepted this based on autonomy principle. The case was known as Hans Just case. I think it's from 1978 or 1982. I don't remember the year now, but The case is called is known as Hans Just. It's from Netherlands, and no, it's from Denmark. It's from Denmark, and Hans Just. In the Hans Just case, ECJ decided that the passing on defense, the necessity to prove that the burden of the tax was not shifted to consumer, it's a procedural rule, a procedural provision, and each state member has autonomy to decide about this. So ECJ decided the case, and the taxpayer did not receive the repayment of this tax. And it's funny because after this, many other state members replied or copied the same provision in their domestic tax procedural law to say that a tax, even if unduly paid, is going to be repaid or refunded just if the taxpayer proved that he did not shift the burden to consumers. France did the same thing, Spain did the same thing, Italy did the same thing. And then a few years ago, another case arrived at ECJ from Italy, known as San Giorgio. In this case, known as San Giorgio in Italy, that started in domestic courts in Italy, the same thing happened. A taxpayer had to pay an unduly tax, and this tax was paid, causing a violation to union law. But the ECJ court, the European Court of Justice, they realized that with that first decision from Hans Just, they created a situation in which each state member should not refund any tax that was supposed to be paid, any tax that was paid in violation of union law. And then they decided that in San Giorgio case, they decided that the state members should bear the burden of proof. The state member administration, tax administration, should demonstrate that the tax burden have been shifted to consumers. It's not supposed to just have a presumption that always the burden of the tax is shifted to consumers. And the court decided also that even if the burden is shifted to consumer, it's not a reason not to reimburse the tax, because if the price of the goods were higher, the taxpayers sold less goods, less services, and so there is a loss to be reimbursed also. And the most important point is that ECJ realized that it would be impossible to the taxpayer to be reimbursed of taxes unduly paid in that situation of proof that the burden was not shifted to consumers. And there is a lot of examples. I will talk just about another one, that is the limitation of ECJ decisions' temporal effects, limitation of temporal effects of ECJ decisions. When in Portuguese, we use another word to this reality, but in short is when the court decides something, but this decision is going to be applied just for the future, for example, not to the past. The decision is not going to have retroactive effect. So in regarding to this point, ECJ only admits to establish limitation to temporal effects when there is good faith of the state member that legislated against union law, and when an exceptional damage is demonstrated, and the state member that asks for the limitation of temporal effects has to prove this exceptional damage. In all other situations, it's not possible to limit temporal effects of ECJ decisions, just because the government of the state member is going to suffer some loss because of this, because of ECJ decision. Otherwise, as the court decided, effectiveness principle would be violated. And the important point is that the contrast of these decisions, and there are, as I said, several other examples of regarding to burden of proof, regarding to res judicata, regarding to many other points related to procedural law. These decisions, the contrast of these decisions reveals how procedural law can be artificially used to confirm, to accept, to ratify, homologate violations of rights, of human rights. giving only symbolic effect to the provisions of material law. This contrast shows also how, when the question involves the government, it's difficult for judiciary power to recognize this. Judiciary power, I mean domestic courts. As ECJ case law shows us, only a court distant from the government, distant from executive power of each state member is able to do this. In Brazil, that's the point. The same issues are decided in a very different way. The same issue, the restitution of indirect taxes. Brazilian courts decide in the opposite way of ECJ, in the same way that domestic courts in Europe use it to decide. And the same thing about related to the limitation of temporal effects. This is in Brazil, indirect taxes are not reimbursed if the taxpayer does not prove that have supported or beared the burden of the tax unduly paid. And judicial decisions against the government are usually and arbitrarily limited in their temporal effects. We do not follow the same guidelines that ECJ prescribed to union law or to state members to make limitations in their temporal effects decisions. These were the issues that I would like to bring to our reflection. A few things that I was going to say, Professor Dunja already said in a much more complete and clear way, so I made a shorter presentation. This analysis between assessed human rights and comparative analysis between Brazil and Europe. I would like once again to say thank you to everyone for this opportunity, and I'm available for questions or for a debate further. Thank you very much.
Thank you very much, Professor Hugo. Any question? Students, where are our students, our Brazilian students, our Croatian students? So thank you so much one more time. And I'll pass now to Professor Denise. I will invite to Professor Denise Andrade. She will talk about women's reproductive rights and the Inter-American System for the Protection of Human Rights, some leading cases. Okay, Professor Denise.
Hi, everyone. Again, good morning and good afternoon. I would like to congratulate Professor Hugo and Professor Dunja for their speeches, and thanking Professor Paula for the invitation to participate in this great webinar. At first, I would like to clarify that I will present a more specific reflection than the speeches that preceded me, in order to confirm the huge importance of the international protection of human rights, especially for Latin America. I will talk about, as Professor Paula said, women's reproductive human rights and the importance of the Inter-American System for the Protection of Human Rights and CIDAW, discussing 3 leading cases. I will share my screen, but I will have just some slides, few slides, don't worry. And just to help us to keep together after the other speeches. Well, human rights have been subject of many debates over the 6 decades. And one of the challenges that remains current is the creation and the consolidation of instruments that contribute to the respect and promotion of human rights in national legal systems. The dissemination of decisions and measures for the protection of human rights strengthens institutions, encourages people, and to pursue this path and consolidate a framework of respect for and promotion of human rights, which is essential for moving forward, especially in countries like Brazil. My intention here today is to demonstrate to what extent the Inter-American System for the Protection of Human Rights and the Convention for the Elimination of All Forms of Discrimination Against Women CEDAW, have contributed to the incorporation of human rights at the internal level of the American states, and confirm that their structure stand out for being useful instruments in confronting human rights violations perpetrated within the internal sphere of the American countries, based on the analysis of the 3 cases involving women's reproductive human rights. The inter-American system plays an outstanding role in favor of incorporation of human rights in the American states, and its principal guideline is the American Convention on Human Rights, that has as the main objective recognizing and ensuring a catalog of rights. It is important for us to recognize that the inter-American system for the protection of human rights is part of a region in which most countries have gone through a recent period of democratization, with a growing need to consolidate non-authoritarian and plural institutions committed to the protection and promotion of human rights. Our region still lives with reminiscences of the legacies of dictatorial authoritarian regimes, with a culture of violence, impunity, and a weak tradition of respect for human rights. In this sense, the inter-American system, made up of the Inter-American Commission and the Inter-American Court of Human Rights, lends itself to monitoring the implementation of human rights in the states parties, as agreed in the American Convention. Also, CEDAW, adopted by the UN General Assembly in 1979, aims to confront the various forms of discrimination perpetrated against women in order to respect, protect, and promote their human rights. CEDAW proposes to overcome not only discriminatory actions, but also the silences that make the suffering invisible and harder to be faced. It is understood that CEDAW can be indicated as the most consistent effort of the UN to codify the protection of women, while making it clear that states must design and implement measures that, in fact, eliminate any and all kinds of discrimination against women, both in the public and the private spheres. Here, the Article 1 from CEDAW. Discrimination runs through all aspects of women's lives, and it is not possible to establish a combat perimeter. And there is an urgent need to act on all spectrums in which discriminatory practices or customs are present. CEDAW's Article 12 stands out for making explicit the mandatory access to a good quality health system that guarantees equal treatment for men and women, including those related to family planning and the after childbirth period, including nutrition and breastfeeding. It is important to emphasize that men and women have the right to decide on their family planning through access to information and good education, with states not having compulsory or unauthorized intervention, such as forced surgical sterilizations, which were common in Latin American countries until the last century, and believe me, still happen today. It is unequivocal that in addition to guaranteeing international recognition of the legal and conceptual aspects of human rights, it must be ensured that this translates into their incorporation to internal sphere of American states. These 3 cases serve as a background to assess the contribution of international human rights protection in shaping state practices. The first case refers to CEDAW's Communication 17 from 2008, case Ali da Silva versus Brazil, that deals with the inappropriate care provided during and after childbirth, which caused her death. This case is important because of the relevance of CEDAW within the protection framework of the women's reproductive human rights, as well as its binding force for the signatory states. The second case, Gellman's against, here I think I have the three cases, yes. The second case, Gellman against Uruguay, talks about the decision of the Inter-American Court of Human Rights in 2011, which condemned the Uruguayan state for the disappearance of Maria Gellman and for the abduction and concealment of the identity of her daughter, Macarena Gellman. The third and last case that I will present today refers to Settlement 71 from 2003, issued by the Inter-American Commission on Human Rights in response to the demand presented by the family of Mamerita Mestanzi against Peru for her unauthorized sterilization, which culminated in her death. I am aware that the cases bring different factual situations. However, they are similar in the aspect of the international protection of human rights and access to justice. Analyzing the parity of these decisions, as well as possible advances and setbacks, could help us to understand the role of the international protection of human rights in the search for a broader access to justice, respect, and protection of women's human rights within the American states. On the first case, Aline, which was born in 1974, died in 2002 as a result of negligence in medical care provided at 2 health units in Rio de Janeiro, Brazil. The contest of Aline's death was submitted to CEDAW committee in November of 2007, 5 years after the victim's family filed a lawsuit in Brazil due to the demonstration of the incapacity of the Brazilian state to proceed with the case. As a rule, the CEDAW committee only admits cases that already have been closed in the national justice system. However, in this case, CEDAW considered that the complaint was admissible, despite the fact that the lawsuit was still pending. In view of the unreasonable and unjustified delay in the process, especially the delay in appointing a medical expert and in carrying out legal proceedings, which impeded the progress of the lawsuit. Both the lawsuit and the petition submitted to the CEDAW committee aimed to repair the damage caused to Aline's family, especially her daughter, while at the same time tried to publicize ongoing disrespect for women's reproductive human rights. Pregnant women are guaranteed the right to priority and quality health care, as they are more vulnerable to changes in their health condition. During and after childbirth is essential to overcome the current scenario to avoid maternal deaths caused by preventable reasons. There was a negligence from the doctors about the symptoms that the patient reported: severe nausea and abdominal pain, when some medications were prescribed and exams scheduled only for 2 days later. But 2 days later, Aline's health condition deteriorated, despite having followed all medical recommendations. Upon being hospitalized, doctors were unable to measure the fetal heartbeat, which was confirmed by ultrasound. Labor was induced, and immediately after giving birth, Aline showed clear signs of disorientation. A succession of mistaken and untimely procedures continued to mark the care provided to Aline, which culminated in her death on November 16th of 2002. This is just one of many cases of maternal mortality due to avoidable causes, which confirms that the debate on women's reproductive human rights remains relevant. Brazil, despite having recognized in its response to CEDAW committee that the state failed to guarantee efficient emergency care, stated that it was not a cause, it's not a case of maternal mortality, affirming that the patient had a general abdominal internal bleeding. We should clarify that Brazil adopts, without restriction, the definition of the World Health Organization of maternal mortality. The death of a pregnant woman or within 42 days of childbirth in reason for any cause arising from pregnancy or aggravated by it. Thus, there is no doubt that Aline's death must be understood as a case of maternal mortality, since the autopsy is explicit in indicating as the cause of death a digestive internal bleeding triggered by negligence in the obstetric care provided to Aline. In this context, two issues should be highlighted. One, the causes of maternal mortality are, for the most part, preventable if good care is given during all the stages of pregnancy. And two, women in poorer social economic conditions are the most affected by maternal mortality. The case also highlights the slowness and indifference of Brazilian institutions, health institutions, justice system, especially when there is an intersection of vulnerabilities. We must say, Aline was poor, Black, and a Brazilian woman. The SADAL committee understood that there was disrespect to Articles 1, 2, and 12 of the Convention by stating that Brazil failed to prevent unavoidable maternal death. The committee established also 6 general recommendations, which transcended the specific case, demonstrating that public policies can be, in fact, impacted by international decisions that deal with the protection of human rights. In response to the committee's communication, the Brazilian federal government published a report in August of 2014, through which it assumed full responsibility for Aline's death and for the damage caused to her family. The second case, known as Gellman versus Uruguay, refers to the forced disappearance of Maria Gellman in an advanced stage of pregnancy, which occurred in Buenos Aires, Argentina, in the end of 1976 during Operation Condor, along with Marcelo Gellman, her husband, who was tortured and murdered in Buenos Aires. It is assumed that Maria Gellman was moved to Uruguay to facilitate her concealment, which is why the case was brought against the state of Uruguay, despite Maria Gellman being Argentinian and her arrest having started in Buenos Aires. Uruguay has never made the minimal efforts necessary to clear up the disappearance of Maria Gellman, nor the subtraction and concealment of the identity and nationality of her daughter, Macarena Gellman, born during her imprisonment. Therefore, the case was submitted to the Inter-American system by Juan Gellman, paternal grandfather of Macarena Gellman and father-in-law of Maria Gellman. The Inter-American Commission on Human Rights sent a request to the Inter-American Court of Human Rights in which it requested that Uruguay be held responsible for the disappearance of Maria Gellman, as well as for the abduction and concealment of the identity of her daughter. On February of 2011, the court decided to condemn Uruguay for both the disappearance of Maria Gellman and the suppression and replacement of the identity of Macarena Gellman, while imposing a series of reparation measures, in particular, the search and the location of the remains of Maria Gellman. There was, in this case, a perversion of women's reproductive rights by state agents. The condition of an advanced pregnancy escalated Maria Gellman's suffering caused by psychological and physical torture. In this situation, there was as a worsening of the evils caused by arbitrary arrests, common in the 60s and 70s in Latin America during dictatorial governments, configuring the practice of gender-based violence. It should also be noted that what happened to Maria Gellman is even more serious when we consider that it was not an isolated or exceptional case. According to what was found during the proceedings before the court, it was stated that this was another episode of a contest of disappearances of pregnant women and illicit appropriation of children that occurred within the framework of Operation Condor. There was the creation of a standard conduct by the state, which chose to transform motherhood into an instrument of torture against women. The court did not limit itself to discussing such debasements, but assuming international commitments that obligate the state to investigate and penalize acts of forced disappearance. Uruguay could not have remained silent in the case of Maria Gellman, under justification for the application of the Uruguayan expiry law. The court demonstrated that an international decision can be decisive in altering and aligning the state's conduct. In this sense, the international protection of human rights helps in the incorporation of these rights within the internal scope of states, since it provides transparency to the processes, supports the victims, encourages people and institutions to continue denouncing abuses against human rights, aligns political actions, and even stimulates national movements to change legislations, as occurred with the repeal of the expiry law of Uruguay. The third and last case refers to the forced sterilization of Mamerita Mestanzi, a practice that is repudiated by international human rights institutions and documents. A petition was presented to the Inter-American Commission in order to investigate the circumstances in which Mamerita Mestanzi was submitted to a surgical sterilization on March 27th of 1988, which culminated in her death on April 5th of the same year. Jacinto Salazar, Mamerita's husband, denounced the head of the health unit for manslaughter on April 15th of 1998, 8 years after Mamerita's died. A month later, the prosecutor formalized the criminal complaint, which was dismissed by the judge 45 days later, and the decision was confirmed by the higher court, culminating in archiving the case. The widower sought assistance from non-governmental organizations in order to question the Peruvian state about the circumstances of his wife's death. The petitioners point out that Mamerita Mestanzi and her husband, Jacinto, were harassed several times at the public health units to sterilize the woman, and reported that several threats were perpetrated against the couple, such as reporting them to the police, alleging that the Peruvian law determines that a person who had more than 5 children must pay a fine and be taken to prison. The unreasonable insistence on performing surgical sterilization is attributed to the fact that Mamerita had 7 children and was a poor peasant. It can be said that there was a state position of understanding poverty as disabling, which would authorize the imposition of birth control on people categorized as unfit to have several children, even though nothing concrete could be attributed to them, nor Mamerita or Jacinto, that discredits them to exercise family power in the sense of being considered careless or neglectful. On the 9th day after surgery, Mamerita Mestanzi died by a generalized infection caused by a bilateral tubal obstruction, making undeniable the direct relation between the surgical sterilization procedure and the patient's death. It is noteworthy that the intervention was carried out without any prior examination to ensure that she was in a good state of health, which would minimize the dangers of elective surgery. It is not a coincidence, but a repeated practice in Latin America, especially until the 80s, when a process of mass sterilization of women in developed countries was established under the justification of containing the poverty and help improve the population's living conditions. It was only in the 90s that the excessive number of female sterilizations began to be questioned by feminists, organized civil society, and also by some health professionals. Mamerita Mestanza is just an example of disrespects and abuses perpetrated by individuals and states against women's reproductive human rights, in an affront not only to basic human rights, but to explicit provisions in international documents. It is understood that the Commission played a relevant role in this case, both by publicizing this episode, which resulted in Peru's acknowledgement of its responsibility, and by granting some reparation to the family and compelling the state of Peru to reaffirm its commitments to the protection and promotion of women's human rights. No unilateral decision was reached, but an agreement was settled. The relevance of this instrument at the disposal of the Commission is noteworthy, since it enables the collaborative construction for the demand, which as a rule is faster, less costly, and with a higher rate of compliance with the agreed terms, which translates into respect and promotion of human rights. In conclusion, the three cases presented converge in the reflection of the difficulties faced to ensure respect for the women's reproductive human rights. The multiplicity of states involved, Brazil, Uruguay, Peru, proves to be a widespread problem in Latin America. Furthermore, the diversity of facts. First case, death due to poor quality and careless medical assistance in the case of Aline da Silva. Second, torture enhanced by the instrumentalization of the pregnant body and the death of Maria Gellman and the subtraction and concealment of the identity of her daughter born in prison. And third, sterilization under coercion and the death of Mamerita Mestanza shows that much needs to be done in protecting women's reproductive human rights. The lack of proper obstetric medical care, which violated the premise of providing medical care free of any kind of discrimination based on gender, race, socioeconomic status, resulted in an experience of maternal death due to avoidable cause, having even been declared by the CEDAW committee that it is a systemic problem in Brazil. It was concluded that Brazilian state was unable to ensure effective judicial protection. In the search for the investigation of arrests, murders, and disappearances during the period of military dictatorship in Latin America, international institutions for the protection of human rights have been extremely relevant for questioning and sometimes overcome the harmful effects of auto-amnesties decreed by those governments. It is in this context that the illegal imprisonment, torture, and forced disappearance of Maria Gellman are asserted, which led to Uruguay's conviction in the Latin American Court, Inter-American Court for the violation of the right to life, personal integrity, and freedom, as well as for abduction, concealment, and replacement of the identity of her daughter born during the incarceration. Finally, Mamerita Mestanzi represents the need to continue reaffirming the concept and legal contours of reproductive rights, especially for women, in order to hinder state access with regard to birth control, which can culminate, as in this case, in the coerced sterilization of a 33-year-old woman and led to her death. In conclusion, the path taken by the CEDAW Committee, the Inter-American Court, and the Inter-American Commission, respectively, confirm that the international protection of human rights is a capable instrument to bring about changes in the behavior of states, sometimes with the payment of indemnities, sometimes with the adjustments of practices and behaviors, through the elaboration and implementation of educational actions, changes in legislation, and adequacy of public policies. Thank you very much to you all.
Thank you so much, Professor Denise. It was a pleasure to listen to you in this specific team. So anyone want a question? We still have 4 or 5 minutes. No, no one, nobody. I'll take, please, you open your camera for we take our last photo. Oh, and we can see our Croatian colleagues. Wow, what a beautiful guys. Okay. Okay, smile everyone. Thanks a lot. So Teacher Dunja had to leave due to another commitment now. On the name of the Unicristos Master Program, I would like to thank everyone for their presence and attention during these 2 days in this international webinar about access to justice and human rights. Thank you so much. We had a high audience in these 2 days, so we are very happy, and I hope this is just our first partnership between 2 institutions, Unicristos and Osijek Law School. So thank you so much. The event was saved on YouTube at Unicristos page, okay? So if you wanna see again and again and again all time, so enter in the YouTube Unicristos and you can review the event. Thank you so much. Good afternoon in Croatia and good morning here in Brazil to you all. Thank you, Professor Hugo, Professor Denise. It was a pleasure to listen to you. Okay, bye-bye.
Bye-bye. Thank you very much.
Ciao.
Bye-bye.